Yes, you can do that. And a version of that in the patent side is called a provisional patent application. So what happened is during your conception of the new product, you probably have a list of the features it's going to do and how you would implement those features. So with that information, you can do a brainstorm and put all that into a provisional patent application. The application can be informal. It doesn't have to be in all the legalese. As long as you have the technical information in that provisional application, now you have reserved the intellectual property right to your product at an early point in time. Now, what happened is a year after you file that, and presumably by then you have developed a fully flushed out product. What you do is you take that provisional application and get the IP lawyers to come in and convert that into a non-provisional application. And then it starts its journey going through the patent office to become an issue patent. So that's how you protect your invention as early as possible.
Let's talk about between two co-founders of a company. How do you if you are both developing a product together, how do you determine, who owns
gets
the
on the
product?
patent?
Yeah.
So let's say you have a situation where multiple people cooperated to come up with a new product or a new service. How do you determine who are the co-inventors of that new invention? Well, in general, as a company, that determination is not so important because you can list, everybody into there, and then as long as they're obligated to assign it to the company, who's listed on the patent, it becomes less relevant, right? So some companies take the policy of we're going to just be inclusive of listing the inventors. Others, they take a more legalistic view of who should be an inventor. And the legal view of who should be an inventor is who has contributed to at least one claim of the patent application. And so if you haven't seen a patent application before, the application has generally three major things. First, it has a textual description of how the invention operates. It has a set of drawings that dovetail with the text to explain how the invention operates. And then at the very end, you're going to have what is called the claim. The claim basically defines the metes and the bound of your invention, very similar to like your property, the description of your property in a deed. So the claims basically outline the things that you think are novel and that no one else should be able to enter that particular space. So generally in an application, we have that claim. And what we do then is once we have the claim drafted, then we says, okay, well, who contributed to this claim? And then we go down that channel for each claim. And then that's how the total list of the inventor would be arrived at. So the correct answer, that's the correct way of determining inventorship. But, in many large organizations, many people contributed to the development of a product, and it depends, right? You could overly inclusive and, but as long as the asset is assigned to the company, in the end, it's all irrelevant. So that's the way we select inventorship is based on the claim.